Good morning, everybody. It is 10 o'clock on the dot, and welcome to our Tea at 10 session for the month of June. So this month we are talking about estates, and we are talking about the kinds of things that you need to be aware of and what you can do to plan in advance. All right, we're going to try and keep this as practical as possible, because I think a lot of what happens when people do estate planning is that the practical stuff is left out. And actually, the practical stuff makes a huge difference for your family at the end of the day, if anything should happen to you. So to start with, we're going to watch a little video. It's slightly humorous. It is from one of our partners that we have partnered with, Capital Legacy. But I think the message in it is very good. So let's have a watch.
You have a 1.2% chance of writing off your car, yet you have car insurance. You have a 0.12% chance of losing everything in a fire, yet you insure the contents of your home. You have a 100% chance of dying, yet 70% of working South Africans die without a signed will. And when there's no will, there's anxiety, uncertainty, and fear. It's a serious problem that leaves loved ones behind with no sense of security and a lot of unnecessary drama.
Okay, so I thought the stats that they quoted were very interesting, because for a lot of us, we wouldn't consider driving on the road without car insurance. And yet the chances of us having an accident is so small. The fact is that eventually we are all going to die. And yet so few people go out and make sure that they have a valid will in place. So I think this is something that we really do need to talk about and do need to make as easy for people and accessible to people as possible. All right. So as the slide says, this is not a doom and gloom session. We're not here to scare you about how terrible it's going to be one day and how your family are going to be left stranded. This is more of a let's make sure that we have everything in place so that your family don't have to have a treasure hunt if anything happens to you. You know, it's often the small things that make a difference. So if I talk about some personal experiences that we've had, we had a client, a very elderly lady, and her husband had been clients for some time, and lovely couple. He passed away, and she came to us and she said, I need help, but I need help with the small stuff. Like, how do I know if the DStv debit order is going to go off? And it might seem like a strange thing to be worried about when your husband's just died, but there's a lot of comfort in being able to do normal stuff, day-to-day stuff that you did every day before you lost a loved one. To be able to continue doing those things helps. And a little thing like watching your favorite show on DStv makes a difference. So it made us realize, or it made me personally realize, you know, sometimes we don't think about those practical types of things. How do we change the DStv account, the Netflix account, things like that? So that's why today's session, we want to be practical, and we want to actually really help you prepare for what to do and how to make sure that your family are going to be able to continue if something should happen to you. All right, so today's session is not about death. It's about reducing stress for your family in the time when they don't need to be having extra stress. So first thing, how do you know if you need an estate plan? It's very simple. You own stuff, you pay for stuff, you love people. Everybody needs to have some sort of an estate plan. No man is an island, all right? We've heard that before. You are connected to other people, you are connected to other things. And so even if you have a very tiny estate and you hardly have anything in your name, you still need to have a plan. Because the plan isn't about just the financial part of it. The plan actually covers more than that. So we're going to look at three different things. Firstly, your wishes, your money, and your admin. So those are the three sectors that we're going to look at. What must happen? How's it going to be paid for? And how do we actually practically do it? And each one of those requires you to go away from today's session and do something. Right. So I guess the bad news from the session is that this session actually requires you to leave and to do some work, because none of this stuff, a plan can't come together unless you sit down and devote a bit of time to it. So yes, this is going to take you some time to sort out. And when we go through the different things, you'll be able to see exactly where you need to put that time in. So let's start with your wishes. Okay, so in order to tell people what you want to happen if you pass away, we all know you need to have a will. Okay, so that's the norm. We know. Okay, only 70%, less than 70% of us actually go and get the will done, but we all know we need to have a will. Then there's a thing called a wish list, different from a will. Okay, and a beneficiary nomination, different from a will, and then the funeral or burial wishes that need to be done as well. All right, so let's look at how those things differ and basically what needs to be done for each of those. So we start with the will. All right, the will is obviously the legal document, and it needs to be done to comply properly with the legal requirements of South Africa. So it must be witnessed. For example, the person who witnesses can't also be a beneficiary. It needs to be signed. You need to appoint an executor. And if you go to any decent attorney, the bank or the partner that we use, Capital Legacy, they should be able to give you a valid will. Okay, so the will is the first part. It tells us what's going to happen, and it governs your estate. Your estate is all the things that you owned in your name. Your car, your house, your investments, your furniture, everything that was in your name. Okay, so when we do a will, we firstly want to be specific. We don't want to say things like, please distribute my estate fairly to my children. That's not useful, because who gets to decide what fairly is? You need to be specific. I have 3 children. Please split the estate equally between them. Specific wording, all right? We also don't want to try and govern from the grave. So, I've had people come and say, oh, when I die, I want my house to go to my son, but I want Granny to be able to live there for 5 years. And then after 5 years, Granny must get this. And it's very difficult to legally implement arrangements like that, because the will is a legal document. Anything that you put in there, the executor is required to make legal arrangements to carry out. And legal arrangements, if you want Granny to be able to live there, that means now we must set up a usufruct. Now that becomes very complicated, because now we got to get attorneys involved. It costs a lot of money to set these types of things up. They've got to be governed. So that's where the letter of wishes comes in. Okay, so the letter of wishes is instructions that you want to give to the humans in your family to tell them what you would like to happen. All right, so maybe you want to say, I would like my dog to be able to sleep on my bed until it dies. You can't put it in the will, because how's the executor going to come up with an illegal arrangement that your dog must sleep on your bed? Like, it's practically impossible. The letter of wishes is the things that you would like the humans to know, that you would like the humans to carry out, that maybe are not enforceable by law, but that you have some sort of good faith in these people to do for you. All right. So for my children, a letter to each of your children. These are the things that I would like for you from life. Or perhaps a letter to the guardian of the children. My children are in such and such school. I would like them to be able to stay in that school if possible until they matriculate. So it's not legal instructions, it's preferences that you would like to see carried out. And those 2 documents, you should really have both, because where the will comes in, it's very legal, and it's very specific, but there's a whole lot of feelings and a whole lot of things that you would like to have happen and messages that you would like to give to people. And so you need to do that separately in your letter of wishes. All right. So 2 different documents. One is legally binding. The other one is, I would like it to be like this, but it's not legally binding. All right. So those are the first 2. Now, what about beneficiary nominations? Beneficiary nominations are nominations that you're going to make on things like your retirement annuities, your retirement fund with a company, or a life cover company, a life cover. Okay, so these are things that in order to have a beneficiary nomination, the product needs to have what's called a life license. Okay, but essentially it's your RAs, your retirement fund, endowments would fall into that, and then also the life cover that you have either personally or with the company. A beneficiary nomination is not governed by the will. They are two separate things. So if you have a product that has a beneficiary nomination on it, that money that pays out will never go into the estate, which means the will never govern it. So if you have said in your will, I want everything that I own to be split between my 3 children, but your life cover beneficiary is your oldest child, you cannot now expect that when the life cover pays out, because the will says split it between the 3 children, it will be split. The beneficiary nomination is a standalone. It has nothing to do with the will. And that beneficiary nomination will govern the product that the beneficiary nomination was made on. Okay, so you need to make sure that all the beneficiary nominations are updated and are in place for any product that there could be a beneficiary nomination. If you do not put a beneficiary nomination on the product, then that money will pay into the estate and will be governed by the will. The drawback of having that happen, and we're going to get to the financial part, is that when those products pay into the estate, it increases the value of the estate and it increases the estate expenses. So it is better to have a beneficiary nomination. It means that it will reduce the fees on that estate, and it means that your family will get the money faster, which is important. Okay, because these days estates can take 2-3 years to wind up, and they can't be waiting 2-3 years to get the money that they need to live on. What about children? All right, so many of us have children that are under 18, that are minors, and we need to understand, how does it work if I was to pass away? All right, so sometimes there are perfectly nuclear families, a mom, a dad, children. Okay, so in a situation like that, you might think, okay, well, it's a little bit more simple, because if I pass away, my husband's here, he'll take care of our children and make sure that whatever they need is taken care of. The part where it becomes a little bit less simple is where there could be an absent parent. So you have a child, the mother or father of that child is not involved, they are absent. Now, a lot of people will then assume that because that parent is absent, they do not have rights as a guardian if they should come back after you pass away. In South African law, it would be exceptional circumstances for even an absent parent not to get the rights over that child. The other people in the family, your parents, your siblings, whoever, who've been helping you take care of that child, would have to prove that this absent parent is not fit. Otherwise, your child legally will end up even with an absent parent if they come and challenge the guardianship. All right, so where does that get complicated? Okay, well, obviously it gets complicated if your child has had an absent parent who now comes and takes them, and that's obviously a pretty traumatic thing. But it also gets complicated from a financial point of view, because if you haven't nominated a trust for those children, whoever the guardian is gets the money. So it depends which insurance company with. A lot of insurance companies are getting smart on this one, and they have it in their policy wording that if you leave money to a child, it has to pay to a trust. But not all insurance companies have that wording. And so if a guardian says, I want the money paid directly to me and not into a trust, the insurance company doesn't have the right to override that if it's not in the policy documents. Okay, so if you are in a situation where you have a child, you are not in a relationship with the child's other parent, be aware that that doesn't necessarily mean that whoever currently helps you look after the child is going to automatically be the guardian. Doesn't work like that. And also be aware of the value of a trust to protect that child's money, to make sure that whoever inherits that money actually is going to use it for the benefit of a child. And that's where trust comes in, because the trust forms a barrier between the money and the person looking after the child. And the trustees will ensure that whatever money is coming out of that trust is reasonable and is actually being used for the benefit of the child. For example, they would pay school fees direct to the school, not to the guardian, stuff like that. Also, just to think about, we don't like to think about these things, but if you're married, you're in a perfectly good relationship, everything's wonderful, the other parent loves your children, and you trust them to take care of your children. When you pass away, they could get remarried. Okay, and then you don't know what influence their new spouse has over them. So I always recommend that something be left in trust for the children, even if it's not a full amount, a portion at least, so that you guarantee that your children will get something from your estate if circumstances should change. All right, so set up your will. Be aware of how the guardianship thing works. Okay, because it doesn't matter what you say in your will, you can't override the law. Set up a trust for minor children. Decide what goes into the trust for the minor children, what goes direct to your spouse. Make that decision. If possible, discuss it together and make it together. And then write the letter of wishes to the people in your family as to what you would like to happen. A message to your children, a message to your husband, your wife. So that's the will part. Okay, I just want to have a look at the question quick because I think it relates to this specific part before I go on to the financial part. One moment. Okay, so there is a question about someone in Australia inheriting money from South Africa. Will there be a problem? There's no problem leaving your estate to somebody outside of South Africa. The estate pays taxes within the estate. So any tax that is paid is paid out of the estate itself, not by the heir that's inheriting the estate. So her not being a taxpayer wouldn't be a problem. Okay. Please explain in detail what is a trust and how it can be set up. All right. So the trust is a legal arrangement whereby, let's say you leave your company life cover to your child who's under 18. If you pass away, so nothing happens if you don't pass away, there is no trust. Only if you pass away, a trust is opened. And what happens is the trust is in the name of a child, all right? So the beneficiary of that trust is your child. And the trust is a legal arrangement whereby the money pays into the trust account and is invested by trustees. At Winston Wealth, we use what's called umbrella trusts. So what happens there is it's one big trust company and they run trusts for lots of different children. And the reason we do it that way is to reduce fees. Okay, because running a trust is quite expensive. So to run a trust, just one trust for one child is expensive. To run a big umbrella trust for 10,000 children is obviously a lot cheaper. So a trust will be open with your child as the beneficiary. The money goes into the trust. Okay, so let's say there's 2 million rand sitting in the trust. Then the guardian, whoever looks after your child, speaks to the trustees and says to the trustees, okay, I need to pay school fees, I need to pay food, I need to buy uniforms, there's a sports tour this year, blah, 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 blah. The trustees look at the request for money and they will say yes, 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 oh, no, yes, 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 oh, no. Okay, so they decide what is reasonable to pay to the guardian for the child and what is not reasonable. They will generally pay things like school fees, sports tours, uniform direct to the school. They will pay the money for transport or food to the guardian. But if the guardian comes and says, I need 20,000 rand a month to feed this child, they're obviously going to ask some questions because I'm sure you could spend 20,000 rand a month feeding a child, but most people wouldn't. So in terms of that, the trustees are a barrier between the money and the guardian. So if the guardian wants to spend any of the money on behalf of the child, they have to request permission and they have to request a payout from the trustees. So the benefit there is that the guardian cannot go and blow the money on things that have nothing to do with the child, or maybe they're actually like really well-intentioned, nice human being who really wants to look after the child, but it's just really bad with money. Because we have those too. You know, like sometimes the person that you would want emotionally to look after your child is not the person that you would want financially to look after your child. So their trust is very useful as well, because you've got this really beautiful human being who's going to take care of your child emotionally. They're awful with money, but that's okay because we've created a barrier between the money and the person using the trust. Okay, so if you want to talk more about setting up a trust or how you go about doing that through a will, you're welcome to give us drop a request in the chat for us to contact you, or drop us a request afterwards. Okay. There is a question about a parent who's legally forfeited their parental rights. Okay, so in a case where there's been a legal forfeit, then obviously guardianship will not automatically pass to that parent. The guardianship will then pass to usually whoever you've nominated. Obviously, they do check it to make sure that the child is going to be best off with that person. But it will usually be, you know, you would nominate someone the child knows, someone that you know will treat the child in the best interest of the child. But if there's been an actual legal giving up of the rights to that child, you can't then go back afterwards when the parent dies and goes, oh, no, I want my rights back. Okay, that doesn't happen. Because obviously, sometimes a step parent has actually adopted the child legally. So in that case, the legal rights have passed to the step parent. Okay, so I think that answers that question. So yes, Bontle, if you have completed a beneficiary nomination form, the policy, the life cover policy, the retirement fund, whatever it is, will not then pay to the estate. Just on the retirement fund, the retirement fund is governed by the trustees. So if you nominate your cat as the beneficiary of your retirement fund and you have 4 children, the trustees will override that nomination. So the trustees of a retirement fund will have to check who your actual financial dependents were. And if they see fit, they will override your beneficiary nomination. Okay, so if you've left most of the money to your oldest child and you've got a 2-year-old, they're going to switch it around. They're going to leave more to the 2-year-old and less to the oldest child. And they have the right to do that when it comes to a retirement fund. So life cover, funeral cover doesn't apply. Whoever you put down on the piece of paper, the money's going to. But a retirement fund, trustees have the right to override your beneficiary nomination. Okay, I'm going to carry on and then I'll come back to the questions because we're going to run out of time. The financial part, right. So the financial part is really about liquidity. So here, a lot of the time, the emphasis is on making sure that there's enough money for your dependents when you die. Okay. And I think, guys, we all know if we have children, we need to make sure we've got some cover in place so that if anything happens to us, it pays out to our children. And we spend a lot of time, well, from what I've seen what financial planners do, is they spend a whole lot of time trying to make sure nothing goes into the estate so that you don't pay fees, which is sort of right, except that there's a big problem with that. There's a liquidity problem. So the estate itself needs to have enough money to pay for the stuff that's going to happen in terms of fees and debt. Okay. So families will often struggle not because there isn't enough wealth or assets in the estate, but because there isn't enough cash, liquid cash in the estate. So there's 2 different things. So one of the things that we need to be cognizant of is that, yes, we don't want to have too much cash in the estate because, okay, it's going to push up the fees that you pay. But there does need to be enough cash to pay for some of the stuff, or all of the stuff, preferably. So, for example, your funeral and burial costs come out of your estate. Okay, so if there's a funeral cover, that's great. It'll be used. But if there's a shortfall, comes out of the estate. Executors fees, 3.5% plus VAT of the value of the estate. Masters fees, you got to pay the master's office 7,000 Rand. Advertising costs, transfer costs, conveyancing costs, tax. The year that you die, there's a final tax assessment, and any exemptions and rebates that you were entitled to as an individual fall away because you're not an individual anymore, you're an estate. And then, of course, outstanding debt. So if we look at a little example here, okay, so this is Zoe, and Zoe's done really, really well because she has managed to accumulate assets in her life. All right, so at Zoe's death, she had her house, she had 2 rental units, rental places, a car, and her bank account in her unit trust. She also had some life cover and a retirement fund from her company, but those don't come into the estate. She had beneficiaries. So her estate's worth 3.7 million. So you would say, well, sure, I mean, there's plenty in that estate. But the problem is that she also then still had some debt that was outstanding on the houses and the car. So she owes 966,000 Rand to the various banks that she took loans with. How much liquidity does she have? The liquidity that she has is her bank account and the unit trust that can be cashed in. So there's only 2 sources of liquidity. Everything else in her estate is a solid immovable asset that would have to be sold to generate cash. So if we look at her estate fees, right, she's going to pay 148,000 in executors fees, 7,000 masters fees. There's conveyancing and transfer costs to move the houses out of her name. And then she's still got to pay the tax, the funeral, the municipal clearances, the certificates, all of those types of things. So including the debt, she has a liquidity shortfall of 1 million Rand. So she has an estate with enough in it to cover everything that needs to be covered. But there's no cash in her estate. She had life cover, she had a retirement fund, but she put beneficiaries on it. So that money didn't come into the estate, which is smart because it doesn't increase the value of the estate. But now the estate can't pay for itself. Okay, and this is where things can become tricky, because now you've got to go to the heirs and you've got to say, you guys need to put money into the estate so that we can wind the estate up, because we can't do it now. Okay, so when you do estate planning, just be cognizant of the fact that there needs to be enough liquidity in your estate to pay for these things. Now, this is where we've partnered with Capital Legacy, who assist with doing your will, which is part of it. But what they really assist with is indemnifying you against these costs. So basically, they don't pay money into the estate and increase the value of the estate to cover the costs. What they do is they don't charge you the fees. So you pay them a monthly policy fee, whatever it is, depending on the value of your estate. And then when you pass away, they don't pay money into your estate to cover the fees. They just don't charge you the fees. So the smart thing there is that it doesn't increase the value of the estate, but it also takes away the liquidity problem. And that's the main reason why we've partnered with them, is because we think it's a smart model. So if you're interested in being contacted by them, you can also just drop us something in the chat. All right, so financially caring for your family, there are some practical questions. Will there be immediate cash? All right, so the debit orders have to go off your bank account. Is that going to happen? Or is there going to be no money for that to happen? Debts what cover do you have on those debts? How are those debts going to be paid? And then the dependents, making sure that there's going to be enough income for your children, your spouse, and who's going to manage the money. All right, so that's the financial part. Let's get to the practical part. Sorry, we have gone a bit over time. Okay, the practical part. Now, this is the part where I say a lot of people never get to. Okay, so you go to a financial planner, they're going to give you a wonderful estate plan because they want to sell your life cover. But they don't think about this part. So this is the part I want you to pay extra attention. All right, practical. What do we actually do to make sure that our family know where all our stuff is if we pass away? Accessing your information. Okay, so there's 2 things you're going to need here. You need an emergency document pack. So this is a pack with all your important documentation in. Certified copies of your ID, your marriage certificates, the birth certificates of your children, policies that you have, your will, the title deeds to your houses, your car licenses, all of that kind of stuff you need to have certified copies of. Okay. Second thing, account details. And this is a live list. Okay, this is something that's going to be updated constantly. Your bank accounts. Who are your bank accounts with? Subscriptions. So you've got Netflix, you've got Disney, you've got whatever. Who are the subscriptions? What are the account numbers? Investments, your SARS details for tax. Okay, because trying to access your e-filing after you've died is impossible. Trust me, we've done it for estates. You cannot break into SARS without the person's passwords. Notice for the vehicle licenses. Maybe the vehicle license is about to expire. Now it can't be renewed. Your retirement fund, all that kind of stuff. Okay, but guys, please, you cannot create this stuff and stick it in a file and stick it in your cabinet at home, because when someone breaks in, they are going to steal it, and then all your details are with someone very undesirable. So that is not how we store this. Okay, how do we store this? All right, you have to have layers in order to make sure that your information is secure. All right, so your first layer is your documents, so the copies of all the documents. You want to be able to put the copies of all those documents somewhere safe. And obviously, cloud storage is a good place to start, but not just cloud storage, because someone can break into the cloud storage. There are different types of vaults that you can use. And for those who aren't tech savvy and know how this works, you're welcome to send me a message, and I will send you some information on it, because I've done a bit of looking into this to set it up for our clients. Okay, so for example, if you've got OneDrive, you can open a OneDrive vault, which sits inside your personal OneDrive, but it has extra layers of protection to be able to get into it to get copies of those documents. Okay, so your first layer, documents in the cloud, preferably in a vault. Number 2, passwords. Do not keep the passwords in the same place where the documents are. Okay, because now you've got this lovely document about what all your accounts are, and then there's another Excel spreadsheet there with all the passwords to all the accounts. But that's not smart, because if someone hacks that, well, you know, now they can just get into everything in your life, and you're not dead yet, because you're busy keeping this for people. So your passwords need to be kept separately in a password manager, an encrypted password manager. And there are a few that are available that are very good, where basically you get access to this thing. You can keep all your passwords there. There's multi-factor authentication, so it's not just like that you put a password in to get into it. It'll do a face scan, or it'll link to a one-time PIN on your phone or something like that. Okay, so documents, passwords separated securely. Legacy tools, right? So legacy tools are things that you can set up on like your Apple account and your Google account. So imagine now all the photos I've ever taken. Okay, you can't see my cell phone, but all the photos I've ever taken are on my Apple cloud. Now my family can't get them because they don't have my Apple password. So what you can do is you can create a legacy contact. And what happens is Apple, so I know the Apple system because I've used it. Google, I think, is similar. But whoever my legacy contact is, it creates a one-pager with a QR code that I give to them. They scan that QR code, they can upload a copy of my death certificate. And when they upload that, Apple will give them access to my cloud. And they'll be able to get all my photos and everything off the cloud and have access to that. Okay, so legacy tools, really good idea. And then the last thing, now this is what you keep at home, the instruction sheet. So the instruction sheet is, dear husband, dear wife, dear kids, whatever. This is where my will is. This is who my executors are. This is my company HR contact person. My documents are sitting on my personal vault. My passwords are sitting on 1Password. My legacy tool has been given to this person. Okay. And obviously, what you can do is you can then, for the people that you want to be able to break into that stuff, you can give them password tips. Try not to give them the actual password. All right. So you've got to set it up in layers to be completely secure. And you've got to make sure that there's specific people who know how to get into this stuff. Otherwise, you set it up beautifully in layers and no one can ever hack your layers. And then, well, they can't get anything. So like I say, if you want some more information on this, I'm happy to get it. When we send out the follow-up email, the newsletter, We'll also give you a list of the documents for the document pack, a list for the accounts pack that you should be using, and some information about how to use the vaults, the encryption for the password, the legacy tools and stuff like that. All right, but this is how to do it, not a file at home in the bookcase, please. That's very dangerous. Okay, so that is it. A good estate plan leaves your family with clarity, instructions, what must happen, cash flow, liquidity in the estate, and a practical plan so that they know where your documents are, who your accounts are with, and how to get into all of those things. All right, thank you very much. I see some people did have to jump off. I'm just going to go through the questions that I didn't get to previously. Okay, so is it true that a trust is expensive? Yes, so trusts can be quite expensive. It does depend on who you set it up with. So, you know, if you set up a trust, a lot of people think, no, I'll set up a trust and I'll make like my dad and my mom the trustees. The problem with that is they actually have to appoint a third party because a trust is not a simple thing to run. There's accounts that have to be done. There's resolutions that have to be done, all sorts of stuff. So unless your mom and dad are attorneys and they know how to do it, I wouldn't personally. You can appoint one of them as a co-trustee to make sure that there's someone who knows you that's part of that trust. I'm quite comfortable with using umbrella trusts because obviously we've experienced how they work and how they interact with the guardians. So I'm quite comfortable with that. But if you want to set up a trust specifically with trustees that you know, do it. Just understand you're going to have to make sure there's enough money in that trust to cover those fees because attorneys are not cheap. Neither are accountants. Okay. Is a family trust the same as a trust for a child below 18? No. So they're not the same thing. A family trust is something that you would set up probably while you're still alive. And the purpose of a family trust is to take the assets out of the name of the individual and put them in the trust. So usually if you run a business or something like that, and you know there's the chance of there being a financial problem with the business, you don't want them to like liquidate your family home and everything to pay off business debt, you'd move stuff into a trust to protect it. Your children can be the beneficiaries of a family trust, and if you've got a family trust, you don't also need to then set up a trust specifically for your children, as long as there's enough assets in the family trust to provide income to your children until they are of age, and as long as the children are the beneficiaries of the trust. Okay, so you don't need both necessarily. Okay, Jocelyn, we will contact you. You'd like part 2 of the discussion? Yeah, definitely. There's a lot more to this. And we will make both the slides and the recording available on our YouTube channel, and we'll send it out via the newsletter. Bondle, what forms part of an estate and what does not form part of an estate? Okay, so Bondle, basically everything in your name except something that has a beneficiary nomination goes into the estate. Bank accounts, tax-free savings plans, unit trusts, properties, your car, your furniture, your clothes, everything goes into your estate. So doing a proper estate plan from a financial point of view is fairly important because you want to make sure that you minimize the size of the estate so the fees don't get bigger, but that there is enough liquidity in that estate as well. But everything goes into your estate unless there's a beneficiary nomination on it, like a retirement annuity or life cover. Okay. All right. I don't see any more questions. Does anybody else have a question that they'd like to ask? Yes. What's Betsy?
Yes, thank you for that. Thank you for the information again. Just wanted to follow up. Do you guys also establish family trusts?
No, so we are not attorneys.
Assist?
Yeah, we can assist with advice of whether you would need one or not. But if you actually want to set one up, you'd have to approach attorneys.
Thank you.
No problem. Okay, well, if that's the end of the questions, we thank you so much for joining us. I think we definitely will do a part 2 of this. I was thinking the practical part about how to store your documents and stuff, probably want to do a little bit more of a deep dive into that, because I myself was learning when I started researching how to actually secure everything properly. So I think that'll be something quite useful to people. But thank you so much for joining us, and we hope to see you next month. Enjoy the rest of your day, everybody.